Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name remains Aaron Asiedu Entry. Today we are looking at the procedure in removing a justice of the Superior Court of Judicature and the Chief Justice. And I have with me here a friend of mine, a government spokesperson. He's in government, and also an LLB candidate at the University of Ghana, Mr. Julius Kwame Anthony. Julius, welcome to the
All right, thank you very much.
How are you?
I'm good. You?
I guess when I go, I want to be like you. The suit and everything clearly shows.
You that you are almost a lawyer. See, if people look at you and they know who is the big man here.
No.
And all.
Maybe you see, bad eating habits can also inflate your body.
No, it's not true. You are naturally a giant.
Okay, so today, just as I mentioned, we are looking at the procedure. Particularly, we'll be dealing with Article 146 of our Constitution, 1992. But don't forget that this video is proudly sponsored by Vian's Groceries. Vian's Groceries. They are located at the Parakou Link at Dome in Accra. Whatever grocery you want, you should just call the numbers on the screen. I'm sure they should be able to serve you in any part of the country. Julius.
Yeah.
Now, you see, when you look at Article 126 of our Constitution, 1992, it talks about the types of courts. We have the Superior Court and we have the lower court. The Superior Court being the High Court, the Court of Appeal, and the Supreme Court. And Article 146 is talking about the procedure in removing two classes of persons. A justice of the Superior Court, meaning a High Court justice, a Court of Appeal, Supreme Court,
and the chairman of the regional tribunals.
I think regional tribunals.
They are non-existent as we speak.
Well, yes, I think the AG currently wants to introduce public tribunals and others. So we'll find another time and talk about that. But what is generally Article 146 talking about?
So when you read Article 146, the first thing you would notice is that it spells out the grounds upon which a justice of the Superior Court of Judicature may be removed from office.
Sure.
And as we have earlier agreed, it means that any of the justices from these courts, the High Court, the Court of Appeal, the Supreme Court, and even though it's defunct, Chairman of Regional Tribunal, it spells out those grounds. People typically say it's 3 grounds, but I say 4 because they may be different. The first ground is stated misbehavior.
Stated misbehavior.
The second ground is incompetence. The third ground is infirmity of the body. And then the fourth is infirmity of the mind.
Okay.
And so for beginners, we need to get that it is only on these grounds that someone may call for the removal of a justice of the Superior Court of Judicature. So for me to actually get a justice of the Superior Court removed, I must first be alleging that he has misbehaved, and I must show that misbehavior.
You are using yourself as an example for the purposes
of this conversation.
Else people will think you are
I am not.
Oh, you are?
I am not.
You are not?
I dare not.
What, you dare not?
I dare not make such a petition for any of our law lords to be removed. Because I don't.
Is it that you fear because you'll be writing entrance exams this year?
Oh, no.
Okay.
Not because of that, but I have always said that if you are entering into a certain environment, you need to accord some respect to those who are in there. You don't go pursuing people who have several years of seniority to you at a time where you yourself have not yet joined the petition. Of course, that is not a relinquishment on my rights as a citizen when necessary to make such petitions, but I'm just of that view, so I dare not. So I must be able to demonstrate any of those 4 grounds for me to actually make a case for the removal of a justice of the Superior Court of Judicature. Beyond that, the Article 146 spells out what procedures must be followed. So if you see clause 2 of 146.
Let's stay on the
grounds. Sure.
My problem is stated misbehavior. Maybe you might find some code of conduct for the judiciary amongst others. But the word incompetence, it has been used loosely in our political language.
Yeah.
The 2016, 2020, 2024.
Yeah.
People even tell their boyfriends and girlfriends
that they
are
are
now
incompetent boyfriends,
What will qualify to be incompetent? That is a problem I'm having.
Well, the word in its ordinary sense means a lack of capacity to perform a certain function.
Okay.
And so in my view, when it comes to a judicial officer, then that would mean that the person lacks the capacity to perform, the functions of a judge for whatever reason. But in simple terms, that's what I think it.
Example of that.
Well, if you are able to show that the person lacks the legal sophistry, would you be that which would be very difficult to show, admittedly. Maybe one of the grounds for saying someone is incompetent. I am drawing that borderline because someone may be incompetent by reason even of infirmity of mind and body.
Sure.
But that has been stated as a separate ground already. But so typically, I am of the view that sort of incompetence would mean that a person lacks that capacity to get the job done, either by reason of lack of legal knowledge or whatever that may be. That would be what to qualify as incompetence. I must say that it is a ground that is so overly broad and does not necessarily point to anything specific. So broad that anything can fit under it, depending on the circumstances.
You don't think that the vague nature of it clearly also, when you are considering our principles of legalities under criminal law, vagueness is a problem.
Yeah, it's a problem.
You don't think it leaves so much discretion to those who would be in charge of this procedure?
It does. I think it is for same reason that the Constitution itself has created some sort of, I would say, buffers around. Because if you look at 1464, there's a committee made up of people. I mean, they are interconnected in a way. I will come to it specifically, but you realize that there's a sort of buffer in terms of the nature and character of the persons that are supposed to be on such committees. You realize that in the case of persons other than the Chief Justice, there are 3 people who are supposed to be judicial officers, justices of the Superior Court of Judicature. Then there are persons who are supposed to be, for lack of better words, laymen. They must not be members of Council of State. They must not be parliamentarians. They must not be lawyers. What I see is the rationale behind it is some sort of judicial knowledge in terms of the people who are judges. Then there's some level of, what do you call it, to ensure that there isn't, some prejudice, political bias, all of those things, because members of parliament and all of that. Then some public interest and accountability also comes in there. That's why they expect the people to be ordinary citizens who are not necessarily lawyers, and the lawyers are mostly the politicians anyway, and all of that.
True.
And in there, so there are those buffers that may curb those things in theory, but indeed practically, I must admit that couching, a ground for which a justice of the Supreme Court to be removed as vague as that, I think is really problematic. What should be done, in terms of recommendations, is that we must find a way to streamline it, to point to specific things going forward.
Sure. So, Julius, now the grounds are clear.
Yeah.
Those 3 in the Constitution, you make it so clear, and I think I side with you.
Yeah, because I may be bodily infirm by reason of problem. I'm unable to move, or I'm unable to move my muscles and all of those things, but my mind would remain intact.
Sure.
And that's why I'm saying that even though it appears as 3, in fact it is 4.
So we look at stated
misbehavior, incompetence, infirmity of body, and then infirmity of mind.
So these are the grounds.
Yeah.
It should fall in any of these, or it should be all the 4.
No, any of those grounds. So if I say that you have misbehaved, I must be able to demonstrate to that committee that misbehavior warrants the removal of Chief Justice. If I say you are incompetent, I must be able to demonstrate that this is an incompetent, the likes of which should constitute a ground for which you should be removed. If I say that you are bodily infirm, I must be able to, show that, you are unable to perform the functions because you are sick or something of the sort. If you look at, at Article 1468, it says that the whoever is accused or whoever the petition is against is entitled not only into legal counsel but other aspects. So strategically, the Constitution ensures that if it ties into the grounds, for which a person may be removed. If it is in a case of an allegation of infirmity of body or mind, then the expert would have to be either a psychologist in terms of mind or a doctor, depending on the nature. So you realize that there's that correlation between the provisions that are there. So I must be able to show that an expert must come to the conclusion that, okay, indeed, this person's mental state is no longer one that is fit for the person to be a justice or a Supreme Court. Or a doctor or an expert in whatever field that is necessary must be able to show that this person is not in good health, that would be able to, warrant his stay in the superior courts. That's either the High Court, Court of Appeal, or the Supreme Court.
So we now clearly understand the grounds for the removal. Now let's start with the procedure proper. And I want us to look at first a justice of the Superior Court. I agree, and we all know that the Chief Justice is a justice of the Superior Court. Let's put the Chief Justice aside and look at any other justice of the Superior Court, being at the High Court, the Court of Appeal, or the Supreme Court. What is the procedure?
Now, if you realize 1462 says that a removal will follow the processes outlined in this
the justice of
section.
The Superior Court of Judicature or a chairman of the regional tribunal may only be removed in accordance with the procedure specified in this article. Meaning Article 146.
Yes. So if you look at 146.3, the summary of it is that a justice of the Superior Court, other than the Chief Justice, so where the President receives a petition involves a justice of the Superior Court other than the Chief Justice, the President would forward it to the Chief Justice for a determination of a prima facie case. To that effect.
I would come to what a prima facie case is. But is it per the provision, if I'm to read Article 146.3, this if the President receives a petition for the removal of a justice of a Superior Court other than the Chief Justice or for the removal of the chairman of a regional tribunal, he shall refer the petition to the Chief Justice, who shall determine whether there is a prima facie case. The point is, does this expressly exclude the President, who is a citizen of the country, the number one gentleman of the country, from he himself, Somutu, commencing the action of removing a justice of the Superior Court?
Well, if you look at it, it would appear so that the President, because he is the one to receive the petition, but he as a private citizen, the President is no longer a private citizen in his capacity. He is limited in that regard from the look of things.
So into constitutionalism.
Yes, because the President is limited in that regard. The reason is because there are the jurisprudential theories of separation of powers and checks and balances are, should I say, you find traces of them. There are those undertones in the provisions over here. You realize that even though it is the President that receives the petition, it is a committee other than the President that looks at it.
Even in 146.3, he's always only conveying it, referring it to the justice to establish
And again, I am of the view that there is a particular reason why it is the President as head of the executive who receives the petition. It is to fulfill the check element in checks and balances. It's to fulfill the check element, because if a petition is against members of the judiciary and the petition goes to them, they may simply ignore it. You get it. But if it is to the President, there is the check element that he remits it, and so the executive arm is aware that there is this action that has been commenced against them. So there's that level of checks and balances over there. And so because the Constitution would not like a unilateral action of a sort, where the President himself sits down and says, I want to get out a member of a co-equal arm of government. So he cannot initiate such an action. It must of necessity come from other citizens, citizens other than the President.
So now the clarification is clear now, because the President is head of the
co-equal arm of government. So you realize that beyond that, I mean, some traces of that, what you call it, separation of powers and checks and balance elements that run throughout. Realize that even if it's the President that receives it, is a committee set up in the case of other justices. Even in the case of justice, we will come to, is a committee that the President is not a part of completely. But when it comes to executing the findings or the recommendations of those committees. It is the president who does it.
I think we'll get it.
Yeah, we'll get it. It's a president. So you realize there's those check and balance elements right in there,
Right.
and separation of power elements in there.
1463 tells us clearly that the Chief Justice is to determine whether there is a prima facie case.
Yes.
I think prima facie has been in our system for quite some time. Whether it is prima facie. What do we mean by prima facie case?
You know, in my view, I think that it is on the, on the face of whatever allegation has been made. Is there a basis for further inquiry to be made into it?
We are just looking at whether there is a basis for
further inquiry to be made into the matter. So anytime a petition is made and it gets to the Chief Justice's duty in the case of other justices of the Superior Court of Judicature is to examine the petitions that has been made and come to a conclusion whether or not the claims in there warrant a further investigation into the matter. And so that determination, the Chief Justice has to how he or she wants to go about making that determination. From the practice, you typically, the Chief Justice invites the justice that is involved.
Okay, that was a question I was about asking because you see, Anthony, the point is you are a justice of the Superior Court.
Yes.
A private citizen like myself, Aaron Asido Entry, brings an action against you.
Yeah.
The point here is that is it proper that the Chief Justice gives you the opportunity as a justice of the Superior Court to make an input or give a response to the said petition to enable her establish the prima facie case, or because the prima facie case, just as you've explained to us, is just to establish whether there is a point or there is a matter or there is a need for further inquiry. Should we, is it the case that per practice or per case law, is it the case that we hear the other side, i.e. being the justice in question?
So I have my own theories on why I think it is necessary for the justice involved to be heard. First is that the rules of natural justice, that persons be heard, even though in the determination of a prima facie case, on most of the issues, you don't necessarily need to hear from the person because you are just looking, okay, is there a need for further inquiry? At the stage of that further inquiry, the person has all the liberties to justify why the petition against that person should not fly. But I think that the person should still be heard on these two grounds because there's no need for unilateral exclusion. The Constitution has not expressly said that at the stage of prima facie determination, the person should not be heard. That's the first ground for it. So what's the point of preventing them anyway? They should be heard. The second ground is that if you look at the grounds for removal, not all the grounds lend themselves to a mere, overt examination of matters and coming to a conclusion that there is nothing. For example, if I allege, that a justice of the Superior Court is mentally, unstable, and for that matter should not remain on the bench, it's a matter of public interest. From the outset, the matter would be
just blown out of proportion.
And if you listen to Justice Dateba in the this thing case, what do you call it? Ejechum case. Yeah. One of the concerns he had about publication is that typically when that happens, the judge will be tried in the court of public opinion without an opportunity to respond. In the same light, when you come out and say that in a case of an allegation of a mental, a challenge, you come out and they say, a prima facie case has been determined. You see the sort of indictment you put on that justice, where people will begin to think that, hey, my lord is not stable. I think that for that reason as well, because when people are looking at the grounds of petition, they look at the ones we have received so far. None has so far, involved a claim of infirmity of the mind or body. But if you look at such an issue and the fact that concern has been there, is it not even better more prudent that at a very early stage we should be able to dispense with it. Because again, if you look at the language of clause 8 of 146, it says that all the proceedings, all the proceedings will be held in camera, and the justice would have an entitlement to be heard, including a right to what? Counsel and other aspects, paraphrasing the provision. Is it not prudent that at the point of, determining if indeed a justice is mentally infirm, he's entitled to get an expert opinion at the outset and lay the matter to rest?
Sure.
It's more prudent that is done. So if you look at it from the angle of non-unilateral, exclusion, and you look at it from the angle of even prudence, it's just reasonable that we do that and prevent those
I think
issues.
in the Justice Derry case, or Arthur Derry case, the court even held that on the prima facie case, we must hear the justice in question.
Well, there is an argument which, of course, strictly speaking, is valid, that it was an obiter, dictum. So
also goes
of course, indeed, if you see, I read that judgment, and if you see the reasoning, that flowed from that judgment, I am of the view that it is one of those what do you call it, non-binding, pronouncements of the court that should be taken seriously. I'm of the view that it is one of those that should be taken seriously. By the reasons I have earlier stated, that the issues that are in Article 146 should not be looked at from the perspective of only the ones that have already happened, but broadly what Article 146 is saying, all the issues that may come out of it, some of them require that as quickly as possible, if there is no merit, those determinations should be made. You can't look at my face and say that I am mentally infirm. You must actually see certain patterns, and when you see those patterns, in fact, an expert may need to adduce some of this. Why do we want, if it's not in the public interest, that as quickly as possible, if there is no merit to such a claim, it should be dispensed with?
Sure.
You get it? And so if it is in the public interest that if there's no merit to such a claim, it should be dispensed with, then we must conduct ourselves in a way such that the provisions of the 1468, which requires the experts' entitlements that the accused justice may have, can kick in quickly.
Sure.
Yeah.
Okay, so Julius, now, President has gotten a petition. He's ferried it to the Chief Justice. The Chief Justice has been able to establish a prima facie case. What happens next?
Well, when the Chief Justice establishes a prima facie case against the person, it goes on to provide that the Chief Justice may then, in consultation with the Judicial Council, appoint 3 persons. So the Judicial Council in this case has a crucial role to play. They would make that appointment. 3 persons who are justices of the Superior Courts of Judicature or chairpersons of a regional tribunal. So it can be a blend of them. So you may be 2 justices from, let's say, the High Court or the Court of Appeal or the Supreme Court, and 1 chairperson of a regional tribunal. Now we don't have a tribunal, so practically it is only the so 3 of them. And then 2 other persons who are neither parliamentarians, lawyers, members of the Council of State and all that. And as I earlier stated, the rationale is that some judicial expertise need to be on board. Some public interest and public accountability interest is there. And then the necessary need to avoid certain prejudices and biases is there. That is why they said parliamentarians should not be there, to avoid political party biases being there, or what do you call it? Partisan interests being there and all of that, and then public interest, so that people would be able to look into what is happening. And so those are the rationales that are behind the nature and character of persons that are supposed to link to the case. When they make a determination, when that committee makes a determination, then it would be remitted to the president, and the president is bound to actually follow whatever recommendations. So
the president has no discretion.
The president has no discretion whatsoever. No discretion whatsoever. As I was saying earlier, there are, certain jurisprudential undertones, including the doctrines of separation of powers and checks and balances. You would observe that typically, when it is the executive that enforces judgments, whatever form they take. It is the executive that enforces judgment. And so when this determination is made, the executive does not have discretion in terms of how to enforce the judgments of a court. I mean, it is not necessarily a judgment of the court, but I'm saying that these, principles.
There's a quasi-judicial.
Exactly. These undertones exist over there. And so it is the executive that must enforce them, because you don't have discretion ordinarily when there is a judicial finding to determine how you want to enforce it or whether you want to enforce it. That is the reason why the president has no say whatsoever. So once the finding is made, the president is obliged to execute it as has been made.
Right. So that is it for a justice of the Superior Court.
Yes.
Now let's look at the Chief Justice.
Yes.
What is the procedure?
Yes.
Because when I read my constitution, I get to see that with the Chief Justice, there is no establishment of prima facie case.
Yes.
But I heard President Mahama ferrying the petition to Council of State to establish a prima facie case. Why is it that all these things are happening?
The reason is because of the case of Ejechume and Attorney General and Akwete.
Okay.
If you read 146, you will not find anything, as you have rightly indicated, that there must be a determination of a prima facie case. But the court reasoned that, one, the Chief Justice invariably must be a justice of the Superior Court of Judicature. In fact, if you see our court structure, the Chief Justice is a member of all the Superior Courts.
Yes.
In fact, all yes, indeed. So if you look at the Court of Appeal, there's no composition of it without a Chief Justice. If you look at the High Court, there's no composition of it without a Chief Justice. If you look at the Supreme Court, all that. So invariably, the Chief Justice is a justice of the Superior Court of Judicature. And so it is just reasonable that there must be some determination of a prima facie case in the case of the Chief Justice as well. Now, beyond that reasoning is also the fact that there's a requirement that a committee be formed to determine the matter, as we have earlier discussed in the case of the other justices. If we are to give a literal interpretation of the Constitution to suggest that in the case of the Chief Justice there's no requirement of a prima facie determination, it would mean that all 31 million of us, anytime at all anybody makes a petition to the president, straightforward, form committee. It means that if we have, very unscrupulous individuals who for some reason decide that all the time they'll be petitioning the president for the removal of a Chief Justice, every day the president will have to continue.
Some are unscrupulous, some are not. But the point is, people are born like that.
Of course.
I had a colleague back in law school. He was called the barrister, Divansa. Barrister can write 10 petitions in 3 days.
It reminds me of Legon. There were some people who were experts in removing SRC executives. There is no SRC executive during the time they were in school that they have not petitioned for those SRC executives to remove. Anyway, I was a serial petitioner, in Legon at a point, because there was an administration that every day they had issues anyway. But then,
barrister would have about 3 grounds to petition the dean or director about opening registration portal. But you see, all these 3 grounds, you divide them
into sub-grounds.
And each of them comes with a petition.
Different petitions. So
I called you.
Why not put it in one?
I named him IGP.
The issues of petitions.
Shout out to you, Diva Zalu.
Anyway,
right.
So to avoid, that absurd situation, the court took the view that it was the intendment of the framers of the Constitution that in the case of the Chief Justice, the President and the Council of State would determine whether or not there's a prima facie case against the Chief Justice. And so that is the reason why the procedure for the Chief Justice as well involves the determination of a prima facie case.
Right.
And so when there's a determination of a prima facie case, in the case of the Chief Justice, the committee is similarly the same but somehow different.
Okay.
The reason is because unlike other justices of the Superior Court, where any 3 justices of the Superior Court of the Judicature or a chairman of a regional tribunal may be involved, in the case of the Chief Justice, It is only justices of the Court of Appeal, 2 of them.
Okay, 2 justices of the
Supreme Court, pardon me, of the Supreme Court, who can be on the committee.
Because your subordinates cannot be checking.
Precisely.
Okay.
Precisely. There's that respect for seniority, which is inherent in the practice of law.
Sure.
So it is there.
So one day you will call me a senior.
Of course.
That should be established.
There's no choice about that.
Okay.
There's no choice about that.
Sure.
You are already my senior at equity.
Right.
So in the case of the Chief Justice, you realize that it's only justices of the Supreme Court, 2 of them, who may be selected by the president in consultation with the Council of State. And the president would also select 3 other persons who must not be lawyers, they must not be members of parliament, they must not be members of the Council of State, who would make up a committee of 5.
Okay.
It is that committee who will then further investigate the matter. And where they also make a recommendation, the president is bound by the recommendation they make.
I think, right. So you've made this clear that in both circumstances, the committee's proceedings are held in camera.
Yes.
It is not open to the public.
Yes.
Unlike if you look at Article 126, Clause 3,
yes.
it tells you that all court proceedings are open to the public with the exception of some delicate matters just like this.
Yes.
Now, the president is bound by the recommendation of the committee, meaning the president has no discretion whatsoever in it. But the point here is that we hear that the Chief Justice can be suspended. The Justice of the Superior Court can be suspended.
Clause 10.
How does that suspension come in the conversation?
It comes in the conversation where in the case of the Chief Justice, where a prima facie determination has been made, the president may by a warrant.
So that is discretional.
Yes.
So the president may decide not to
suspend the Chief Justice. May by a warrant signed by him suspend the Chief Justice. Now, the policy rationale, I think, is behind that provision is that the powers of the Chief Justice are extensive. The Chief Justice is the chief administrator of the judiciary. The Chief Justice's position actually is for 2 key things. If you read the Constitution, is administrative and supervisory.
Okay.
So the Chief Justice is the only judge in our whole court structure that individually has supervisory jurisdiction. All other judges, properly so called, only have judicial, supervisory jurisdiction as a court. So the High Court may exercise supervisory jurisdiction over all courts that are below it that way. But when it comes to Chief Justice, as an individual, she has that supervisory authority. Of course. Yes. Over the whole court structure. That's extensive. The Chief Justice also has administrative authority over that. And if you are making an inquiry into the conduct of a person wielding such authority, it is just reasonable that, the person, where it is necessary, stays out of the way. I think that on issues like incompetence, stated misbehavior, for example, depending on the nature of the misbehavior, you may not want the Chief Justice to stay, there. But on matters of, let's say, a claim of infirmity of the mind, in such circumstances where such a grave, allegation has been made and a prima facie determination has been made. And I want to tie this back into my earlier point why I said that it's important that the experts that have been provided for in Clause 8 of 146 should be, hurriedly involved by allowing the person that opportunity to those experts. Imagine experts find in the determination of a prima facie case that a Chief Justice is mentally infirm. As president, you may want to ask that, please step aside.
But would that not worsen the situation?
In terms of how?
I'm a Chief Justice. You are saying that I'm mentally infirm.
And the prima facie determination has been made.
Prima facie determination mostly does not involve the experts.
It is a very reason why I argued earlier that the broad provision of the 146, the nature of it, even though
maybe
even though it is not explicit that at the stage of a prima facie determination the other person be heard, in the grounds that have been stated in 1461 are such that when you say someone is mentally infirm, you can't just look at the person. Invariably, expert opinion must come in, whether even if it is a prima facie determination, because you can't just look at papers. I mean, even though the what do you call it, the ordinary meaning of prima facie means that just look at the face of the issue and determine if there's a need for further inquiry. For a claim like mental infirmity, it's so serious a claim, so difficult to prove on face value that necessarily you may want to have expert opinion. And because the language of 1468 is all, I'm of the view that it is just reasonable that from inception you get that view. And so in the situation where that prima facie determination has been made, that the Chief Justice may be mentally infirm, the most reasonable thing to do would be to trigger 14610.
Sure.
And suspend for the time being. Let a firm conclusion be made by a committee to the effect that, yes, this claim has merit or does not have merit. Then the Chief Justice may resume. I am using that example because, argumentative. I must go to the extremes to demonstrate why those provisions may be necessary. But ordinarily, if someone is alleging incompetence and all of those things, you may decide. So that is why it is discretionary. You may decide that, well, let's get to the bottom of this matter, even while the Chief Justice is still there, if you think that she may not be an obstacle or he may not be an obstacle to the process. And so, that provision is one that care must be exercised with prudence. It must be exercised with some level of national interest in mind. It is not one that should be exercised with whims.
Sure.
But suspending the Chief Justice raises a whole lot of concerns. It raises public interest. And so it must be exercised only in cases where there's the need for it.
Right.
Yeah.
Does the suspension criteria also applies to other justices?
Yes, it applies to all other justices.
Okay.
Yes, it applies to all other justices.
Right. I think Article 146.11 says that the president may at any time revoke a suspension under this. That is quite clear.
Yeah.
Thank you very much, Julius, for your time.
It's been a pleasure being with you.
Yes, I think it is very elaborate.
Yeah, thank you.
We wish to host you once again.
Definitely. I'm at your beck and call.
Constitutional amendment.
Sure.
This time I would want us to be picking the provisions people have issues with and discuss the history, how it has appeared in our statute books till date, the rationale, having to follow.
In fact, the provision under discussion is one of the areas that I think should be amended. I had the opportunity to present a paper to the IEA on the matter, I think some 3 or 4 years ago. Wow. On it. I'm of the view that it is one of the weak links in our setup, especially if we want to ensure, the independence of the judiciary. We must ensure that the process is a bit elaborate.
Sure.
The removal of a member of a co-equal arm of government, one whose appointment requires, especially, approval of Parliament, must also require the same for the person to be taken out of office. We must look at things that way going forward. Chief Justices, Justices of the Superior Courts, their impeachment or their removal. It must not be a mere removal. It must be an impeachment process that requires some level of parliamentary inquiry. 2/3 majority requirements. I am of the view that those additions should be made if we review the Constitution.
I think it's right because justice itself emanates from the people.
Precisely.
And the representative of the people are there for the to be able to voice the views of the people.
Precisely.
So, Julius, thank you so much. This video was proudly sponsored by Vian's Groceries, located at the Paraku Link. We had Mr. Anthony Kwame Julius, and I believe that you enjoyed the conversation. Thank you so much for joining us. Don't forget, I've always been ending my videos with this. Do not leave all your matters to God. take some to your lawyer. Thank you.